Okay, so if you've been keeping an eye on legal developments in India, today, May 20th, 2025, was quite a big day, a major announcement from the Supreme Court.
Absolutely. It's one of those decisions that's going to, well, really change the landscape for people wanting to enter judicial service.
Yeah, and it seems like these new rules are kicking in straight away for, future hiring.
That's right. Immediately for future recruitments. And in this deep dive, our plan is to really unpack what the Supreme Court decided, focus on this restored minimum practice requirement.
So what it is, why they did it.
Exactly. The what, the why, and what it actually means if you're someone thinking about becoming a judge.
Right.
Our mission basically is just to lay it all out clearly, make sense of it.
Okay, let's dive in then. What's the core change? What did the court actually decide?
So the main thing, the absolute crux, is that the Supreme Court has brought back a mandatory 3-year minimum practice.
As an advocate.
As an advocate, yes. Specifically for getting appointed as a civil judge junior division. It's a pretty significant policy shift.
Okay, 3 years practice. And you mentioned future recruitments. So anything already in the pipeline is safe. Like if a recruitment process has already started.
Correct. The court was very clear on that. This new rule, the 3-year minimum, it only applies to recruitment processes started after today's judgment, May 20th.
Phew. Okay. So no retroactive changes there?
None.
Yeah.
Anything ongoing is unaffected. And they've also told high courts and state governments, basically, update your rules.
Right. They need to amend their service rules to reflect this. Makes sense.
Exactly.
So 3 years practicing as an advocate, it sounds simple, but legal stuff always has details. What counts as practice? Is it just arguing in court?
That's a really important point, and they clarified it. Experience you gain working as a law clerk. That counts.
Oh, really? Any law clerk?
For any judge or judicial officer anywhere in the country, that experience will be counted towards the 3 years. Yeah, one of the articles quotes it directly. We further direct that the experience of the candidate, which they have gained working as law clerks with any of the judges or judicial officers of the country, will also be considered while calculating the total number of years of practice.
That is significant. So someone could theoretically graduate law school, clerk for 3 years, and meet this requirement.
That seems to be exactly what it means.
Yeah.
It opens up that path quite clearly.
Okay, and what about people who are actually practicing advocates? How do they prove their 3 years? Is there specific paperwork?
Yes, there is. You need a certificate. The reports outline a few ways to get this sorted.
Okay.
One way is getting it certified by the principal judicial officer of the court where you practice.
Right.
Or you could get a certificate from another advocate in that same court, someone with at least 10 years experience, 10 years standing.
But does that need checking?
It does.
Mm-hmm.
That certificate still needs to be endorsed, sort of countersigned by the principal judicial officer.
Okay, so there's always that judicial oversight.
Seems so. And the third option is just getting the certificate directly from a principal judicial officer of that station. So a few routes.
It seems designed to be, well, flexible but still rigorous.
Exactly. And sure, it's verifiable, but hopefully not too bureaucratic.
And what if you practice mainly in the Supreme Court or a high court? Is the process different?
Slightly different, yes.
Yeah.
For those lawyers, they need a certificate from an advocate with that same minimum 10-year standing.
Right.
But the endorsement comes from an officer who is specifically designated by that court, the high court or Supreme Court.
Okay, so specific procedures for the higher courts. Got it. That all seems quite clear on the how. Now the big question, why? Why bring this back? They allowed fresh graduates for 20 years.
Yeah, the court was pretty blunt about it. They basically said that the experience over the last 20 years recruiting fresh law grads without practice, well, hasn't been a success. The phrase used in the report is that it has led to problems.
Problems. Did they elaborate?
Not on specific examples in the reports we read, but the quote is quite direct. For the last 20 years, during which the recruitment of fresh law graduates have been appointed as judicial officers without a single day of practice at the bar, has not been a successful experience. Such fresh law graduates have led to many problems.
So the implication is that maybe jumping straight into being a judge without that practical grounding, it caused difficulties.
That seems to be the core reasoning. The court pointed out that judicial officers, right from day one, deal with really critical issues.
Life, liberty, property.
Exactly.
I mean,
heavy stuff. And their view now is that knowing the law from books, or even the pre-service training they get, it just isn't a full substitute.
for what?
For actually seeing the system work. First-hand experience, understanding how courts run, how lawyers operate, how judges think on the bench.
The sort of feel of the courtroom.
Precisely. They said, let Let me find the quote.
Anyway.
Neither knowledge based on law books nor pre-service training could be an adequate substitute to the first-hand experience of the working of the court system and administration of justice.
So it's about immersion.
It seems so. They continued, this is possible when the candidate is exposed to the working of the court and observing how lawyers and judges function in the court.
It makes intuitive sense, I suppose, that practical wisdom.
And they also mentioned that most high courts actually agreed with this perspective, that some practice is needed to prepare people properly for being a judge, understanding the intricacies, as they put.
Okay. And this isn't entirely new, right? You mentioned history. This was the norm before.
It was, yeah. Before 2002, most states did require about 3 years of practice.
So what happened in 2002?
There was another Supreme Court judgment, also in the All India Judges Association case. So that case seems to come up a lot for judicial conditions.
Right.
And back then, based on something called the Shetty Commission's recommendations, the court decided to remove the practice requirement.
Why did they do that then? What was the thinking?
The idea, or the concern, was about attracting talent. They thought that maybe bright young law graduates, after spending 3 years in practice, might find judicial service less appealing.
Ah, so they might get established in practice and not want to switch.
That was the fear. The 2002 ruling noted something like, a bright young law graduate after 3 years of practice finds the judicial service not attractive enough. So the recommendation was, let's get them in early, remove that barrier.
Interesting. So the goal then was widening the talent pool, attracting people straight from law school.
Correct. But now, 20-odd years later, the court is looking at the result of that policy.
And deciding it didn't quite work out as planned.
That seems to be the conclusion driving this reversal. The experience of those 2 decades led them back to valuing practical experience.
Fascinating cycle. Was everyone on board with this change now? Did all the high courts agree?
Not entirely, no. It's worth noting, the reports mention Sikkim and Chhattisgarh high courts didn't think restoring the requirement was necessary.
Okay, so some dissent there.
And there was another interesting point raised by the amicus curiae, senior advocate Siddharth Bhatnagar.
What was that?
Well, while he seemed to acknowledge the issue of fresh graduates lacking practical experience, he also flagged a potential problem with the requirement itself.
Which
A
is
risk that people might just go through the motions, do the 3 years of practice nominally, just to tick the box, without really engaging or learning much.
Ah, the checkbox practice problem. That's a valid concern. Did the court consider that?
It seems they did. The report mentions the bench deliberated on the effectiveness, the potential for it to be just a superficial period.
Right. So just having the rule doesn't guarantee meaningful experience. That's a challenge.
Definitely something to watch, how it's implemented and perhaps monitored.
And who were the judges on this bench?
This ruling came from a bench with the Chief Justice of India, B.R. Gavai, and Justices A.G. Masi and K. Vinod Chandran.
Okay.
And again, it was part of the ongoing proceedings in that All India Judges Association case.
Right. So let's try and summarize the key points for everyone listening. Number 1, the 3-year minimum practice for civil judge junior division is back.
Correct. Mandatory 3 years.
Number 2, crucially, experience as a law clerk counts towards this. That's a big one.
Very big, yes. Provides an alternative pathway.
Number 3, this only affects future recruitments. Anything started before May 20th, 2025 is exempt.
Absolutely clear on that point.
And number 4, the main reason is the Supreme Court's assessment, based on 20 years of experience, that practical, hands-on court exposure is essential for new judges.
That's the core rationale they presented. You've summed it up well.
So if you are listening, maybe you're in law school now or just graduated and you're thinking about the judiciary, this is, well, obviously huge news for you.
It really changes the planning, doesn't it?
Yeah, it directly shapes the path forward. That emphasis is back on getting practical experience first, either through advocacy or, importantly now, through clerking.
Which you could argue is maybe a good thing, an opportunity to really understand the system from the inside before taking on that judicial responsibility.
It certainly adds a layer of practical preparation.
And it leads to maybe a final thought for you to chew on. Given this shift back to practical experience,
Yeah.
how might those first 3 years, whether you spend them practicing or clerking, how might those specific experiences, the skills you gain, the things you see, how might they uniquely shape the kind of judge you eventually become?
That's interesting. It's not just about knowing the law, but how that early practical grounding influences your perspective, your temperament, your approach on the bench later on.
Exactly. That balance between the academic knowledge and the sort of messy human reality of the courtroom. Something to think about.